Welcome, everyone. This is our session on rentals, rental bylaws, and short-term rentals. Undoubtedly, people have many questions, so please put them into the Q&A. Lisa Mackie is our guest speaker today, and she always does an amazing job for rentals. We're always really happy to have her join us. Also want to really a big thumbs up and thank you to Landlord BC for being this week's sponsor. And Landlord BC is a great service if you are an owner and you rent your unit out. They're a great service to help you navigate the Residential Tenancy Act and a bunch of the humps and bumps that we go through as we're dealing with the collision between strata corporation bylaws and, of course, rentals within units. This system is recorded. If you submit a question through the Q&A, we try to group them all together to manage the time a little better, but you'll always be free to ask questions afterwards. Whatever you do, don't use personal information like your strata plan, business, or any information that might identify you as an individual. On the question, we will try to keep it as generic as possible. The other thing to just remember is this doesn't constitute legal advice. Anytime somebody asks a question, there's so much more information we would have to gather and the lawyer would have to gather in order to give you a really competent formulated answer. So the answers will be based on the information you give. It's generic information for educational purposes only as we go through this. And there's a great picture of Lisa. That's her email address. If you want to write it down, this is a great opportunity to do that. And her phone number, if you have any additional questions about rentals, that would be great. Your hair looks just exactly the same. I just love that.
You know what? It's all thanks to hairspray, Tony. What can I say?
So here we go. Lisa, it's all over to you, and I'll just monitor questions, and as we go along, if there's something relevant, I'll just pop in with you.
Fantastic. Well, welcome everybody. Hope you guys have something to eat and to drink. I was telling Tony before we started that I can't have any food or beverage around me because otherwise it would be all in my keyboard. So no food or beverages for me right now. Let's talk about the basics of rental bylaws and what we need to know under the Strata Property Act. So as we all know, as council members or owners or property managers, a strata is allowed to pass bylaws. So you're stuck with the standard schedule of bylaws appended to the Strata Property Act. But one of the things that the Act allows us to do is restrict residential rentals or prohibit them. So it's only with respect to residential strata lots, not non-residential strata lots, but we are allowed under the Strata Property Act to pass a bylaw that prohibits rentals or limits the number or percentage of units of residential strata lots that are allowed to be rented. And so if you do have the limit in your bylaw, so you say there's a maximum of 10 rentals in your community, then you need to ensure that your bylaw, in order to be enforceable, has a method of administration and allocation on those rentals. So for example, a priority waiting list. Essentially, how is your rental limit going to be administered? That's key. If you're missing that ingredient, then the recipe for your rental bylaw gets ousted, and it will probably be struck down if you're in a dispute in Supreme Court or the CRT. Okay, there are exceptions to every rule, and with rental bylaws, there's no exception to that exceptional rule. There's three main exemptions. So we have our family rental exemption, hardship rentals, and owner-developer exemptions as well. So on the family rental front, when a tenant is the child or parent of the owner, if the tenant is the spouse of the owner, if the tenant is the parent or child of the owner's spouse, then the rental bylaw will not apply to that individual. They are exempted from the application. The category of family member is very, very specific. So only those ones that we've mentioned here. If you're renting to your uncle, if you're renting to your cousin, if you're renting to your aunt, they count under the rental restriction bylaw or the rental prohibition. So we want to make extra certain that if we are relying on family, that our family is the right family member to be entitled to that exemption as well. Hardship is another one, and this can be a hardship for a lot of councils to administer. So essentially, if a owner can establish a hardship in not being able to rent their unit, and the strata corporation allows that exemption or potentially runs past a deadline on which to decide a rental hardship application, then the exempted strata lot will be not applicable under the applicable rental bylaw or the prohibition. So we don't count those when we are administering that rental bylaw restriction as well. And then last but not least, we have the owner developer exemption. So straight out the gate in the development of your community, there might be an exception to any bylaw that the strata passes down the line that restricts or prohibits the rental of residential strata lots. So there's a little bit of a chronology here for rental disclosures that were filed before January 1st, 2010. So we have stratas that were filed, they're operational before that date. Then the exemption will apply for first purchasers only. So as soon as the exemption period in the disclosure statement expires, or if any earlier, the transaction of the transition of the strata lot to someone else, so a sale, then that exemption no longer applies and the strata lot's captured under your rental restriction bylaw or your prohibition as well. For anything filed and operational after January 1st, 2010, then it doesn't get married to the strata lot owner. It's actually tied to the strata lot. And so the strata lot will be exempt for the period of time specified in the rental disclosure statement filed by the developer. One key aspect of that is that when we were talking about stratas that were operational and had their rental disclosure statements filed before January 1st, 2010, a developer might put indefinite as the exempted rental period on those forms, and that would be okay. But under the new exemption, there needs to be a specific period of time. And it might be way far in the future. It might be 200 years in the future, 300 years in the future. As long as there's a specific date on that statement, then it's an enforceable statement, and that strata lot would be exempt from your community's rules going forward.
Lisa, one of the questions that we've had is directly to this, and it's more of a comment, but developers in small developments or townhouse developments will put the exemption for a very limited period of time until they've sold all the units. So we're starting to see rental disclosures since 2010 that only had 5 or 10-year exemptions to them. And I think it's really important for owners and strata councils to look closely at what that exemption date is, because some of them have adopted rental bylaws which now apply to every strata lot because the exemption has expired.
Yeah, and when your time's up, your time's up. And I think that's really an important reminder for councils. So when we're looking at administering our rental prohibitions or our restrictions, we want to make sure we go to the source, and that's the rental disclosure statement. So a great reminder to councils out there to keep their paperwork in order. All right. There are certain limits to what strata corporations can do. So I always say that the strata council is like the royal family of strata community, and you have a variety of characters on the royal family. But there's limits as to what the strata council can do or what the strata corporation can impose. And so under the Strata Property Act, the strata corporation is not allowed to screen tenants. You're not allowed to establish screening criteria. You can't require a strata's approval of a tenant. So you can't say the tenant, it needs to be interviewed or approved by the strata council. Sorry, councils out there. And you can't impose a term in a tenancy agreement either. So very, very hands off when it comes to the actual administration of the tenancy agreement. You can limit the number of rentals of residential strata lots. You can limit the time that they're rented for, but you can't do much more. And so it's really important that when we look at our rental bylaws, that we essentially deploy the BC Lottery Corporation motto, which is we know our limit, we play within it. And so we don't want to stray into those prohibited areas.
So would a bylaw that limits the rental period of a tenant to an owner to a maximum of 3 years at a time before they have to reapply for permission to rent again, wouldn't that be inserting terms of a tenancy in a tenancy agreement?
That's an interesting observation. And yes, ordinarily, I would say that that would be constituting imposing a term in the tenancy agreement, requiring a fixed term. But the Strata Property Act allows us to limit the time period under a hardship exemption in terms of how long you're allowed to rent for, as well as under your bylaws. And so it's sort of, again, an exception to the rule. There is, in terms of some struggles with those fixed term requirements, basically competing interests under the Residential Tenancy Act and the Strata Property Act. So one of the things that was erased in the Residential Tenancy Act in the last couple of years was the ability of a landlord to have a must vacate clause at the end of the fixed term of their lease. And so as you can imagine, it's become quite a difficult land to navigate for councils who want to limit the amount of time of a rental. And so one of the biggest tips that I give for owners who have received a rental hardship exemption for a limited period of time or want to comply with a bylaw that has a maximum limit of time as well, that they sign something called a mutual agreement to end tenancy. So essentially a contract that whereby both the landlord and the tenant agree that their tenancy is finite and will end at a certain point in order to comply with the strata's requirements. So very, very tricky area.
So I guess from the landlord's perspective, this is where a landlord could be left on the hook of liability, exposed to penalties and fines from the strata corporation if their tenancy extends beyond the period that was permitted in the bylaws.
Absolutely. And it's also a struggle for councils because council, you guys are very limited in what you can do in terms of evicting tenants as well. And so one of the recommendations that I have for our folks is when you are giving a hardship exemption, for example, that one of the conditions on the exemption to secure that permitted rental period is to ensure that the landlord signs a mutual agreement to end tenancy with the tenant that clarifies that the rental exemption is only permitted for this limited period of time. All right. And so there's also delaying provisions. So if you have a community that just passed a rental bylaw, then it doesn't apply to everyone at the same time. So if the strata lot is already rented, it does not apply to the current rental. And it does not apply until 1 year after the tenant that's currently renting leaves. And so 1 year after that tenancy ends, then the bylaw will actually apply to that strata lot. 1 year after the bylaw is passed as well. And there's good reason as we want that, because we want to make sure that occupants remain in their home as long as possible, and the community's change of direction for rentals won't have as great an impact as you can imagine if the bylaw was immediately enforceable and everybody had to pack their bags, so to speak. Okay, and so when it comes to counting rental bylaws, math is hard. And this arithmetic doesn't make it any easier. And so there are exemptions to the calculation as well. So family rentals, hardship exemptions, owner developer exemptions, they are not counted for the purpose of administering your rental restriction. And we'll get to a sample that we can work through in that regard, but you do not count those in the administration of your rental restriction. However, the rentals count in your community as a rental. So they need to be identified on every Form B information certificate in terms of the number of rentals that are in the community, as well as you need to make sure as a council that the new tenant has a Form K notice of tenants' responsibilities and that is signed by the tenants. And we'll get to why that Form K is important for your community to get filled out. All right, so let's work through this math problem. So the community in this case has a bylaw that permits a total amount of residential rental to 10 rentals. So 10 residential strata lots are allowed to be rented. And so in this scenario, we have 8 rentals that are permitted under the current administration. And then we have a series of other rentals. We have 4 family rentals exempted, we have 1 rental hardship exemption, and we have 7 owner developer exemptions. So when we're doing the math, when we're disclosing the number of rentals on a Form B, it's 20, because that's the amount of rentals that are actually in the strata corporation, and it educates the buyer that this is in fact a community that has a lot of rentals. But when it comes to administering the rental limit under the 10 rental only bylaw, then you do still have 2 vacancies left. As according to this information, we have only 8 rentals that are permitted and not exempted under that bylaw. So you've still got 2 spots of rental opportunities there.
So this is really a tough thing for strata councils to administer, because it assumes that everybody who's rented has provided a Form K. It
Yes.
also assumes that someone is monitoring this on a month-by-month basis
Yes.
and keeping track of these. It also assumes that they are identified correctly, whether they apply under the rentals or the exemptions. But it follows to a question that somebody's already asked here in the Q&A, and is that, are owners entitled to have the list of units that are rented and tenants under the Act?
Yes, and so this isn't confidential information. These are Strata Corporation records. And so in terms of knowing the number and strata lots that are rented, absolutely. There's no confidentiality ascribed there. There is confidentiality ascribed to the details of a hardship exemption, so something to keep in mind. So as councils, when you are processing a rental hardship application, you're going to be receiving a lot of confidential information about potentially someone's medical circumstances, their financial circumstances. And so when it comes to hardship hearings, it's one that owners don't get audience for. It's only council's ears only. And this is information that is highly private. So something to be kept with Strata Council as well, and not broadcast, for example, in the minutes for everyone to know and love. But no, everyone has a right to know the amount of rentals in a community. Absolutely.
So here's a buyer question that we frequently get. Are buyers entitled to know the breakdown of these rentals? The Form B only tells the total number of rentals, but that doesn't tell a buyer whether there are any rental vacancies.
Yes.
And so, our advice to a buyer is always, with respects to rentals, you need to be aware that your ability to rent may change at some point. Again, depends on if there's a rental disclosure exemption, what's happening, but the ability to do that as an investment could change.
Absolutely. And I actually encourage our folks, when it comes to the Form B, to let them know that if there's room left in the rental restriction bylaw, let them know. We have 2 spots left, for example, in this scenario, so that they're not under an impression that they're not able to rent if they buy, that there's still room there. So the Form B gives a formula for you to disclose how many rentals, but there's nothing stopping you as a community by giving an added layer of information to the prospective purchaser, that just so that you know, our rental restrictions have been at our limit. So there's no subject to any exemptions under the Act. We are at our limit. There's no more rentals permitted in the community at this time, or we do have room. And so I think that's highly relevant to a purchaser who might have specific intentions to the property as well. All right, Form Ks. So I call them Special K. It's like the cereal. So it's something that you should make sure that you have if you're given the choice. And so within 2 weeks of the tenants moving in, the Form K needs to be signed and given back to the strata. And the Form K is important. It identifies the strata lot that's being rented. It verifies that the tenant has received a copy of the bylaws and the rules as they are at the time of the rental. It holds the tenant responsible to comply with those bylaws and rules. But further than that, it holds them responsible to comply with any amendments. So there's a specific, excuse me, there's a specific notation under the Form K where tenants have to agree that bylaws and rules can be amended from time to time, and they're subject to complying with those. And they acknowledge that. So very important document when it comes to ensuring that the tenants comply with the requirements as well. And the Form K lets them know too that any visitors are also responsible too. So the tenants are responsible for their visitors. From the tenant's perspective, there's liability at risk here. So they might be subject to penalties, including fines, denied access to recreational facilities, payment of strata costs to remedy the contravention, and all of that is disclosed to them on the Form K. So it is a critical document in your Strata Corporation's filing, and you want to make sure that if there's a changing of occupancy in one of the units, you follow up. Is this a rental? Is this not a rental? Is this something where we need a Form K? And in fact, if a landlord doesn't supply their tenant with a Form K, or potentially has rented a strata lot without being compliant with the bylaws, then the Strata Property Act actually allows tenants to end their lease within 90 days of learning about that without any penalty, and subject to monetary compensation up to 1 month's rent. So significant document when it comes to administering rentals in your community. Okay, short-term accommodations. So we use expressions like short-term rentals, and they're not rentals. And so it's kind of a terrible expression to use. And I use it all the time as well. VRBO, Airbnb, they're not actually rentals. They're not covered by your rental restrictions or your rental prohibitions. The Residential Tenancy Act does not apply to short-term rental accommodations. They're a business activity. It's a commercial use of a property. It's like a hoteling operation. So if your community wants to restrict or prohibit short-term accommodations, you need a separate bylaw for that. You cannot expect your rental bylaw to cover this. It won't. And you should also consult with your municipal requirements as well. So depending on where you live, your community might not be able to permit short-term accommodations. The municipality might not allow short-term accommodations, or might require licensing or fees to be paid or subject to limits and other administration by local government. So we want to be very, very sure when it comes to short-term rentals. If we want to monitor them, we need a bylaw. We need to make sure that we are alive to our zoning requirements too.
So here's another question that's come up that partly relates to short-term rentals, but is also in relationship to traditional rental bylaws, is home exchanges. So because of COVID in the last year and a half, and hopefully that we're all going to get released from jail and allowed to go around the world,
Yes.
although the jury's out on that at the moment.
Yes.
You know, can we arrange for a home exchange, let's say with somebody in New Zealand or in England or France? You know, can we do a home exchange, or somebody in another part of Canada under our bylaws? Is this something that would be permitted?
So I'm going to say a typical lawyer answer, and it depends. It's going to depend on your bylaw. And the reason why I say that is because a lot of people think the rent has to be monetary. So under the Residential Tenancy Act, rent itself, the meaning of rent, is broadly defined to include monetary value, but any value or any right in exchange for occupation. So there's an argument there that home exchanges are a form of rental, potentially, an argument can be made, but it's really going to depend on your bylaw. It's going to depend on how you define a rental, and what kind of activities you prohibit. Is this potentially a short-term accommodation? It really, really depends on your bylaws and how they define the living situation.
So as well as home exchange, what about roommates? Because the act actually does refer to the rental of a strata lot or part of a strata lot.
That's right.
So how do roommates apply to this?
Yeah, and again, it'll depend on the wording of your bylaw. And so a lot of folks don't have bylaws that prohibit or limit the rental of all or part of a strata lot. And so if somebody is renting rooms in their strata lot, they're living there, but they're renting rooms, depending on how your bylaw is drafted, they might be subject to the rental restriction or the rental prohibition because they are renting part of the strata lot. But it really depends on the wording of your bylaw. And so a roommate renting, regardless of whether or not it's permitted under the tenancy agreement, whether or not it's an owner that's living with somebody, it's all looking at the language of your bylaw. Is your bylaw broadly drafted to say a rental of part of the strata lot counts under this restriction? Or is it the entire strata lot? Because that's where people can sneak in as well. So somebody is not renting the entire strata lot. They're sharing part of the strata lot with the owner. And a lot of bylaws won't apply to that situation.
So we could also technically apply that to things like homestays or international students as well.
I think you can. And I think one of the things to keep in mind is because the term rent is so broadly construed to include any value, there is a really strong argument, depending on the other facts associated with how long the residency is or what rights they have, whether they're paying a security deposit to live there, any other factors, there's a possibility that a rental is created. And that actually is a scary notion to anybody engaging in this process as well. They might unintentionally become a landlord. Okay, Enforcement and penalties. So we want to make sure that we're alive to what our maximum fining provisions are. And the laws were amended over the last few years to allow councils to have more power to penalize folks who are violating rental restriction bylaws or rental prohibitions. Because as you can imagine, particularly in the Vancouver area, you can get a lot of money for a short-term accommodation. You can get a lot of money for a rental. And the old deterrents, the old maximum fines, or even the standard fines under the Strata Property Act schedule of bylaws, isn't much of a deterrent. So the law allows councils to amend their bylaws to fine at a higher amount. So for rental bylaws, you can fine, so long as your bylaws provide for it, up to $500 every 7 days. And for short-term accommodations, it's a bit of a windfall there. It's up to $1,000 per day. And the reason for that is there needed to be a stronger deterrent because, as you can imagine, short-term accommodation is like a hotel. People can, depending on the time of year, rent out all or part of their strata lot on a short-term basis for a lot of money. And the old bylaw framework, the old maximum fines, just wasn't a deterrent. And so $1,000 a day might be. Okay, so under the schedule of standard bylaws, which are the default ones we get, unless we file anything different in the Land Title Office, then the maximum fine for a bylaw infraction is $50, and the maximum fine for a rule infraction is $10. You can't even get a cup of coffee now for $10, depending on the size that you get. And if you're like me, if it's first thing in the morning, you've got a busy day ahead of you, you need that extra large coffee. So not a lot of deterrent with this fining setup. So the Strata Property Act says you can jack the price here. So you can amend your bylaws to allow up to $200 for the infraction of a bylaw, up to $50 for the infraction of a rule, $500 every 7 days for the violation of a rental bylaw, and $1,000 per day for a short-term rental violation as well. So a lot more teeth there that you can sink into for your community management. All right, so in terms of the fines, they're only good if you actually follow the process. And so section 135 is the section to know and love under the Strata Property Act. And incidentally, if you've ever had struggles going to sleep, pick up the Strata Property Act, start reading, and you're gonna be out like a light. But try and pay attention when it comes to 135. So before we're imposing a fine, before we're requiring someone to remedy a contravention or denying them access to a recreational facility because they've broken a bylaw related to that facility, we have to follow proper procedures. So as council, this is the recipe that you need to follow. First, we have to receive a complaint about the alleged contravention. And one of the common questions that I'm asked is, does it have to be a complaint in writing? No, it does not. You can receive as council a verbal complaint from someone, and that's fine. I've had a lot of councils say, well, we refuse to enforce the bylaw unless the complainer submits us with a written complaint. And the act doesn't actually go that far. It just says you've received a complaint. Now, you do, as a council, need to provide the owner or the tenant with the particulars or the details of the complaint in writing. That's where the written component comes in, everybody. So you have to provide written notice of the alleged infraction. And when we're writing our bylaw enforcement letters, there's nothing worse than saying you have contravened a bylaw. You haven't yet. You've yet to be determined to have contravened a bylaw. So it is alleged that you are in contravention of this bylaw. We like that language because you haven't made your decision yet as to whether or not a bylaw has been contravened. Before you make that decision, you have to give the owner or the tenant a reasonable opportunity to answer the complaint, including a hearing if they request one before the council. If it's a tenant, you have to give them notice of the complaint as well, and to their landlord. So there's no arrangement where the landlord doesn't know that their property is potentially being misused here. And after you followed that requirement, then you can make a decision. You can decide whether to fine or impose any of the other remedies. And you have to make it within a reasonable period of time. I know that COVID over the last year has been a struggle for a lot of councils getting together and enforcing the bylaws. And unfortunately, the CRT has been overturning a lot of fines that were administered where a decision on a bylaw complaint was delayed by 2 months, 3 months. It has to be timely. And so they need to be able to get notice of the complaint in a timely manner, and they have to have the reasons for council's decision in a timely manner as well. All right, so in the event the tenant refuses to pay, so the tenant is found that they've been in breach of a strata corporation bylaw, the landlord is on the hook. So the landlord, as part of that arrangement, is going to be liable if the tenant doesn't pay, which is why we're giving the landlord notice of these complaints and the decision with respect to fining or any other costs. That could be the bylaw penalties, it could be damages or reimbursement to the strata for property damage, insurance deductibles, recovery of insurance deductibles, depending on how your bylaws are worded, and potential legal costs, again, depending on how your bylaws are worded as well. All right, so another question that we've been asked, can we apply bylaws or rules differently to tenants? Well, it's not like the class system. We don't have a lower level of occupant in the building. So tenants retain the same rights to use and enjoy the property, and they receive the same rights to enjoy amenities and facilities that are available to owners. So when an owner leases their property, they're leasing to the tenant, they're assigning their right to use and enjoy the property in the same way as everybody else. And their rights are enforceable in the Civil Resolution Tribunal. So a tenant, if they've been unfairly denied access to a residential recreational facility, can apply for dispute resolution and get a remedy against their strata. Can we apply bylaws or rules differently to short-term rentals? Well, remember, short-term rentals are not rentals. They don't actually convey any rights to a tenant. It's just an occupant. It's a transient use. And so the council and the strata corporation do have the ability to administer the property use in a different way. So screening, access, identification, although the Strata Property Act doesn't allow us to do that with respect to tenants, we can do that when it becomes to short-term accommodations. So they're not tenants, they don't carry the same rights or weight that a tenant would as well. So when it comes to facilities like pools, fitness facilities, recreational areas, particularly during the reopening phase now, where we're reopening our community amenities, we can still have the ability to restrict or screen anybody who is not a tenant. So like a guest using the facilities, a short-term accommodation occupant using the facilities as well. All right, and so breaking news, everybody. So I've said everybody into the pool, and this is some news that really shook up a lot of strata corporations and landlords because it didn't come with a lot of notice. So as of July 10th, the laws that were in place during the pandemic that allowed landlords to keep recreational facilities closed to ensure physical distancing during the COVID pandemic were repealed. So ordinarily, when you deny a tenant a right to access an amenity or facility that they're paying for in their rent, if you deny them that right, then you owe them money. You owe them a rental reduction to be equivalent to the value that they're losing as a result of the amenity loss. And so during COVID, it made sense. We wanted to make sure that facilities were kept absolutely closed while we worked out safety protocols and wanted to make sure that everyone stayed apart. But now the laws have changed, and if you want to keep your recreational facility closed, then you have to provide your tenant with rental reduction or some value in exchange for that loss. And so that includes strata corporations if you're renting out a strata lot. And an owner who is denied the ability to allow their tenant to use a recreational facility might have a claim over against their strata if the strata is unreasonably keeping these facilities closed. In terms of some breaking news from the CRT midway through the pandemic had already ruled that in order for a strata to keep their pool closed when there wasn't an immediate health need and where you could operate at a reduced capacity, they needed to pass a 3/4 vote because they considered it a significant change to the use of the common property. It was not being used. So, so everybody needs to be mindful that when we have these amenities available, we can't keep it under lock and key anymore. We have to start reopening. We have to do it safely. If we don't, tenants can get compensation for that. Okay, what other routine questions do we encounter? So one was, do rental bylaws apply to everyone? So Assuming that the bylaw is enforceable and it's passed by a 3/4 vote and registered in the land title office. And that's a nice little reminder to folks. Just because you pass a bylaw at a meeting doesn't mean it's enforceable. You have to take that extra step and register it in the land title office. But it's not going to count to everybody. So remember, we recapped this at the beginning, but those owner developer exemptions will not be captured by the bylaw. The hardship exemptions will not be captured or counted under the bylaw administration, and family rentals as well. And remember, there's also that delaying provision too, 1 year after passing that bylaw and registering it in the land title office, and a year after any current tenant vacates the property as well. Okay, and so existing tenants are exempt. So as I mentioned, it applies a year after the tenant has left, and sales have become a topic of conversation. So the strata councils that I have been coaching over the last year have always asked questions about what happens when you sell a rental property. Does the tenancy end? And the answer is, well, it depends, and not always. So just because a property sells does not mean that the tenancy terminates. A buyer who wants to live in the property, or their close family member that wants to live in the property, can issue a 2-month notice to vacate to the tenant, or the seller can do that as well. But if the buyer doesn't intend to live at the property and doesn't live at the property, the tenant continues regardless of whether or not there's a new owner, and the new owner steps into the shoes of the previous landlord. So just because you have an existing tenant situation where the property is sold doesn't mean that that terminates, and it doesn't mean that there's going to be a fresh crop of people in that unit.
So Lisa, this kind of gets into the kind of obscure collision between the Provincial Strata Property Act and the local bylaws of municipalities like Vancouver, for example, with the empty homes tax.
Yes.
So here we have this issue of my tenant has left. I rented for only 1 more year, which is difficult to find at the best of times. A tenant who's going to move in for a year and then move out, which is problematic.
Yes.
But I rented for a year. Now my tenant is left. There's no room on the vacancy list. I now have a vacant unit that I may be exposed to paying the vacancy tax on.
Yes. Absolutely. There's a price tag attached to that now. And so, and is there an example, or is that potentially a hardship request saying that I can't afford to pay this, or I need to be able to rent my property? And the answer again is it depends. So if there are severely prejudicial financial consequences to somebody, then there might be room for them to wriggle in and get a further exemption. I'm not aware of any CRT decisions that have been made on the vacancy tax at this point, but keep a weather eye out. The CRT pumps out several decisions a day, so who knows. But yeah, I mean, those are factors when it comes to what an owner is going to be doing with their property if they have to keep it vacant under the Strata Property Act.
A little follow-up to that, the province was a few years ago looking at the potential of repealing rental bylaws so that no rental bylaws could be applied or enforced. At this time, we are not aware of any plans to proceed with that. There was a significant amount of pushback from the public, but it was also realized at the time that the buildings that actually have rental bylaws actually have the highest occupancy rates. It's the buildings post 2010 that are used by speculators that have the lowest occupancy rates and the greatest number of empty homes. So there was no real benefit to adopting such a bylaw or adopting such a change to the act at the time.
Yeah, my understanding as well is that the city of Richmond is considering whether or not for new developments as part of their development permit application, it's not been passed yet, but that they would require developers not to include pet prohibitions and not to include rental prohibitions on the basis that they need more rental housing stock. And so it's certainly something that local governments have been chatting about at their levels as to whether or not they should restrict that. And we'll see. I mean, stay tuned to see whether or not that happens.
Yeah, no, exactly. I've never seen a developer include a rental prohibition on their bylaws because it simply limits or restricts their ability to market. But we've certainly seen pet prohibitions on a number of occasions.
Yes. You could even just have the standard schedule one where we permit a reasonable number of fish. And if anyone can tell me what a reasonable number means, give me a call.
Well, we have had a strata corporation that believed that a reasonable number of small caged mammals was 20 gerbils. So,
okay.
So, you know, exactly. If you can tell me what reasonable number of small caged mammals is, that would be really interesting as well.
Well, in my house, any singular rodent would be unreasonable. So gerbils are not, and no offense to anyone who owns a gerbil.
So the next slide is about who pays the cost. There's all these violations and issues by a tenant. Who pays?
That's right. Well, the buck stops at the landlord or the owner. So the tenant can be accountable for this, but ultimately if the tenant doesn't pay, the landlord, the owner is responsible as well. Remember, you do as a strata, when you are looking to get reimbursement, whether it's through a fine or through remedy and contravention, you do have to give notice to the landlord and the tenant, so they're both aware of the bylaw enforcement process. And the strata can bring the collections at the civil resolution tribunal. The landlord can bring their collections to the residential tenancy branch. So in the event that a landlord pays out a fine that their tenant should have paid, a landlord or the property owner is able to sue the tenant at the residential tenancy branch for recovery of those fines.
So now we're down to questions, and we have some really good juicy questions coming
Fantastic.
up here. So one of the things just relates back in clarity to the Form K. The Form K is a requirement of the Act that it must be provided, but the strata doesn't have enforcement ability of the Act unless they have a bylaw. So unless they have a bylaw, how do they enforce it?
Well, first of all, they would have to write to their owner, so that they would say that, listen, the Strata Property Act requires you to sign this Form K, notice of tenant's responsibility, and hopefully they had a bylaw. If they don't have a bylaw, I suppose you could get creative. You could see whether or not the other bylaws might apply here. So is there potentially an argument to say somebody is offside the use bylaw, for example, by allowing a rental where the strata has not received the Form K, where the tenants have not signed on to comply with the bylaws or rules? There could be an argument there. But what I recommend that owners do is replicate the provisions of the Strata Property Act and put it squarely in the face of the owner. This is your legal obligation to your community to have this document signed. Also write to the tenant. There's nothing stopping a strata council from writing to whom it may concern or tenant of the property and posting it on the door and noting the Form K that they need to sign, and see if they can obtain it that way as well. Because the Strata Property Act allows the tenant to terminate their lease if their landlord is not complying with the Form K requirements as well. So hefty pressure that can be provided by way of the tenants or occupants too.
Is there a way, now this is kind of like the $1 million question, and a few strata corporations have gone through this. How can a strata effectively evict a problem tenant when the landlord is not cooperating?
Yeah, and that takes time. And so unfortunately, the strata does not have the ability to go with the residential tenancy branch. And so you have to go to Supreme Court to evict a tenant. And it's a lengthy process. It would be done by petition, so you could do it by petition and affidavit, but you would have to convince the court that the tenant has repeatedly violated a significant bylaw or rule of your community, that they have been given ample opportunity to straighten up and fly right, so to speak, and that they haven't, and that you need to enforce the eviction because the property owner is not as well. And typically these types of claims are also brought against the property owner for failing to do their job. So the one other avenue I've seen some stratas take, which is a creative approach, is that they give the owner the option to say that if you don't want to take them to the branch and enforce your rights as landlord of the property, you can assign us to be your agent to act on your behalf at the branch to enforce the eviction. And technically, is that a way in? Yes, because the Residential Tenancy Act recognizes that landlords include their agents, but I don't recommend stratas do anything that would suggest they become an agent of the owner on a tenancy that they don't have a right to screen or manage or otherwise take care of. So if your community is dealing with a problem tenant situation, then you want to stay on top of your bylaw enforcement with both the tenant and the owner, and ultimately have that sufficient paper trail so when you apply to Supreme Court, the court agrees and says that you can evict, and it would be the equivalent of 1 month's notice to the tenant for what would otherwise be permitted the landlord to issue the tenant under the Residential Tenancy Act.
I think the key here is that the Strata Council has to efficiently and effectively manage bylaw enforcement every time a violation occurs on a monthly basis, and make sure the documentation to the tenant and the landlord is always maintained, because the application to the courts, and there have been a few of them, but very few that have been successful, it's not only time consuming, but it's also very expensive.
It's very expensive. And the other tip that I have for folks is, if the tenants are violating multiple bylaws, send multiple bylaw enforcement letters. Don't bundle your bylaw infractions in one letter, because they're technically separate infractions. So write separate letters. And while administratively it might be a bit of a burden to send out all of those letters, if you do have to go to the court's doorstep and ask for permission to remove that tenant from the building, a 50-page affidavit that shows 50 bylaw infraction letters and decisions is going to be much more persuasive than a bylaw enforcement package that shows 10 letters that bundle certain infractions. It's all about optics. So the more paper you can generate to showcase your enforcement, the better your odds are at succeeding in Supreme Court.
So change gears to hardship. So, and there are multiple questions about this. What constitutes hardship, and how does a strata gather evidence to be able to make a reliable decision?
Yeah, good question. Well, one thing for certain is it's just hardship. It's nothing like significant hardship or extreme hardship. So I've seen some bylaws get passed where they say that the tenant or the owner, in order to apply for a hardship, needs to establish extreme hardship or significant hardship. It's just hardship. Now, the courts have interpreted hardship as something that is extremely prejudicial. It's a hardship of fate or their circumstances. There's no one cookie cutter definition of what might constitute a hardship. It could be financial reasons, it could be medical reasons. It will depend on the facts of each rental hardship application. So there's one of my biggest tips for communities as well is I always hate the expression, well, it'll establish a precedent. There's a precedent here. Well, no, there's not, because each hardship application is processed independently based on the information you have collected or you've received. It's possible that your council will not receive a lot of information from the owner applying for hardship. And as a council, you can deny and invite them to apply again if they can supply you with more information, and keeping that line of communication open, saying that we have reviewed your application, or we've presided over your hearing. You have provided the following. We consider this to be insufficient. You've not provided us with further information and support, which we would need to otherwise consider your rental hardship application. And your request is denied at this time, but you're welcome to reapply later.
But strata corporations can also ask for very specific information to
Absolutely.
verify that the hardship is credible, right?
Absolutely. And so we have privacy laws out there that we want to be mindful of. So we have the Personal Information Protection Act, but it allows us to collect someone's information, personal information, which could be their financial information, their medical circumstances, their name, their family members, who you name it, anything personal about the individual, as long as it's reasonably necessary for the council to make a decision. And so, as you can suspect, the world's your oyster in terms of what you as a council might need to obtain. If someone, for example, is saying they have financial hardship, you might be saying, I want to see your banking statements. I want to see your other sensitive financial information. And you would be entitled to ask that. And if not, if somebody's refusing to provide reasonably necessary information for you to grant a hardship, you can deny. And that's within your right as a council to do so.
So we're starting to see more of this again. We saw quite a lot of it when we were going through all the leaky condo repairs, when people had special levies, but we're starting to see this again as buildings are aging and communities are facing larger special assessments.
Yes.
You know, people are really coming forward and saying, in order for me to pay my special assessment, I really need to rent out my unit on a hardship. And these are probably more common because these are older buildings that have rental bylaws. And so I guess the same test would apply. Is this really going to be a financial inconvenience for you in some extreme case?
Yeah, oh, absolutely. And that's a consideration for council. It's within your sole discretion. You have to act in good faith and reasonably. But yes, these are the circumstances that are becoming more and more common. Apart from older buildings, older adults. So there's a lot of older adults, owners that are living in their homes that are not able to live independently anymore, and that they might be transitioning to assisted living or long-term care. There might be reasons why they need to fund that service or fund certain accommodations by way of a rental. And so that's becoming more and more common too. An owner saying, I have limited financial means, I need to transition to long-term care. I'm asking for permission to rent. The rental revenue will be essentially required for me to be able to get these services. And that raises another issue. It raises human rights issues. So there's a lot of factors that play into a strata's decision as to whether or not to grant an exemption to a rental restriction.
And I think just before we leave this topic, the other warning to owners, if you buy another unit and it's not subject to sale of your strata lot, and you come back to the strata council and say, I can't pay 2 mortgages, that's not necessarily a hardship.
No, that's right. Or selling your property at a loss. I mean, there's been decisions already on that point saying that just because you say you'll have a shortfall on your sale doesn't necessarily mean hardship. And in fact, was not hardship in several circumstances.
Bottom rule, it's up to each strata council to render a decision based on reasonable circumstances.
That's right. You guys are the royal family. You guys need to administer your kingdom reasonably. You don't want an off with their heads scenario and be voted out of the council the next year. But yeah, you need to behave reasonably. You need to enforce your bylaws, create that paper trail, look after your record keeping, review your bylaws. Make sure that you understand what your laws of the land are, because they might be different than your neighbors.
Well, and just to take your statement just a little bit further, just remember your home is not your castle, which is why these bylaws and rules apply collectively to everyone.
Absolutely, absolutely. I once saw an interview with a person in the paper that they said that a strata has no right in the homes of the owners. And I thought, do you know what a strata is?
Yeah, really.
That's all they do. So absolutely, you're right. Yeah, your home is not your castle. It's in a larger kingdom.
One more question as we go along here. Strata councils and property managers frequently treat the owner-tenant list as if it's a secret, and they refuse to release this. But you know, simple rule: owners request under Section 35 of the Act in writing a copy of this, and if they don't get it, your option is a CRT application.
Absolutely, absolutely, and that remedy is there. And I'm not sure where the understanding that we have to keep this private. There's no privacy ascribed to that, and there's reason for that. It's because our community needs to be mindful as to who's living there, how to contact people, and what happens in the event somebody's misusing the property. So knowing who's there and who to go after. So yeah, I mean, these lists are not under lock and key, so to speak.
And they're not protected under privacy at the same time, which is another issue I think that people need to realize.
Absolutely. A Form K is a record of the strata corporation as well. And so I've seen some stratas get into a little bit of hot water by redacting information on a Form K. There's no personal information that can be redacted from that document. It's a record of your strata, and your owners or anyone authorized under 3536 of the Strata Property Act is allowed to get that information.
Lisa, thank you so much. And one more repeat here. There we are again. So
there's my mug.
If you have any additional questions, Lisa, regarding rentals, Lisa would be very happy to assist. Likewise, the office info@choa.bc.ca, and any one of our advisors across the province will help you to navigate this sometimes rather complicated topic, and certainly refer you to legal services if that's something that should arise. Any parting comments on the castle and the royal family?
I think everyone just needs to do their best, and make sure you put everything in writing. That's always my biggest tip for everybody. So no matter how royal you are, you want to make sure that you have a written record of everything.
You know, it's interesting you should raise that, because recently we find a real relaxation on that. And written record of your communications is probably the only thing that will support you if you're making CRT applications.
Well, when you're having a dispute resolution process where everything is in writing, it's a challenge when you don't have a written record. And so I know it takes the extra time, but I don't know about you. I don't remember what conversation I had 2 weeks ago, 2 months ago, 2 years ago. And that might be very important for a matter that erupts in your community down the line. So keeping everything in writing makes sure that everybody is literally on the same page.
Absolutely. Lisa, thanks so much. Landlord BC, thanks so much for your sponsorship. We really appreciate the services. BC Housing is a great partner. If you are on your strata council or as an owner, you can also check out the link on our website to the Maintenance Matters bulletins, which have a significant number of resources for everybody as well. With respects to operations and planning, and there are always a significant number of them under research. I think we have 4 guides under research and development right now. So again, happy to have everyone join. It's such a great great seminar, and we really appreciate anybody's additional feedback if you have any, and everybody have a good, safe afternoon.